theme of this conference is the limits of religious liberty. Typically, we lawyers and legal academics think of limits to rights in terms of balancing or examining the proportionality between one right claim and competing right claim. So we may ask a question like this: does exempting the Roman Catholic Church from complying with gender non-discrimination in the context of the priestly vocation adequately balance the right to religious liberty and the right to non-discrimination on the ground of gender? Here the analysis proceeds by placing two claim rights in contact with one another. I have a right to religious liberty, and someone else has a right to non-discrimination. And the question is then, how do we balance these? What are the limits of each in relation to the other? How far can I press my religious liberty or my right to non-discrimination against someone else's liberty? These are difficult questions, not least because our dominant paradigm for considering them appears to render all claims into formally equal instances of liberty. How do we balance matters that are simply put, my liberty versus your liberty? Of course, some have suggested ways to think through such clashes. Patrick Parkinson and I have argued that we would do well to focus on the different contexts of such clashes. A public university may be different from the plural provision of secondary education, for example. I don't want to reject outright questions of proportionality and balancing as tools for thinking about limits to rights. However, in this presentation, I'm going to suggest that the question, what are the limits of religious liberty, may also require us to ask, what is religious liberty for? In part, this isn't an unusual thought. To illustrate, consider freedom of speech. What is it for? If we understand that freedom of speech is for the development of a person's moral autonomy or discovering their own way of living, then this may affect the scope of claim protection. It becomes plausible to claim that pornography, for example, is a matter of free speech. But if the purpose of free speech is to form a better political community, to engage in speech that helps contest and further claims over what the common good demands, then what counts as speech for legal protection may be different. Pornography may be simply speech outside of the ends or purposes of freedom of expression. Indeed, it may be contrary to forming a better political community. So the question, what is a right or liberty for, is related to possible limits, the boundaries of what we are genuinely interested in protecting or furthering, and how then the right or liberty should be regulated. I want to deepen this thought through a central contrast. I'm going to explore what religious liberty is for through two accounts. Let's call these the liberal tradition and the Christian solidarity tradition. The liberal tradition understands religious liberty as either the central instance of, or else simply a byword for liberty. The liberty of the individual to pursue his or her own understanding of good or their own authenticity. I will suggest that this account perhaps ironically given its stated aim, precipitates an increasing number of limits or potential limits on the formation of religious communities and the practice of religion. In contrast, the Christian solidarity tradition understands religious liberty as existing to support the free creation of communities of solidarity, fraternity, and charity, seeking the truth about God. This account grounds an argument for the greater autonomy of plural bodies, but it also poses a question of limits. Put simply, religious liberty on this account is directed towards the good, entailing building a good society in which religion figures. And so we may want to discern what is and isn't good, what is and isn't religious, truly understood. I think this poses a challenge not simply to the law and how we talk about religious liberty within it, but also to Christians who invoke religious liberty. So first then, to the liberal tradition. For a prominent group of scholars and judges across a significant period of time, the purpose of religious liberty, what it is for, is relatively clear. If religious liberty is to matter, then it must be understood as protecting, essentially, the personal autonomy of individuals. Commentators thus refer to religious liberty protecting an individual's deep commitments, deep concerns, or deep interests, his or her convictions of conscience, a person's moral identity, or else the faculty within which each person searches for the ultimate meaning of life. What we have here are two threads that reinforce and reflect one another: an understanding of religion and an understanding of liberty. Take Ronald Dworkin's Religion Without God. final posthumous book as a key example. Now, Dworkin was a highly influential legal philosopher in the liberal tradition. In this book, he argued that religion is deeper than God. Beyond theism, he claimed that religion concerns two matters: that inherent value permeates reality, including the universe, although entirely immanent, is sublime, and that human life has purpose, found in the inescapable responsibility to make one's life a success. In this sense, all persons are, at least potentially, religious, and fundamentally in the same way. All persons seek objective value as they understand it. All persons, in the words of the United States Supreme Court, define one's own concept of existence, of meaning, of the universe, and of the mystery of human life. We can summarize this line of thinking. For Dworkin, religion is a byword for the individual's quest for authenticity, the individual's quest to find and live out a life that grips you as right for you. This account of religion then supports Dworkin's general understanding of liberty or freedom. He argues that religious liberty should not focus on, for example, the liberty of particular religious groups or those seeking God. Rather, he argues that we must have a more general concern for what he calls ethical freedom. For Dworkin, this means that the government must treat each person's ethical choices, how they decide to live their lives, who they enter into intimate relationships with, their reproductive decisions, and so on, with equal respect. He argued that this supports a new understanding of what classical writers like St. Augustine called the commonweal, or res publica. For Augustine, a true res publica is one that is orientated by a common love of God and neighbour. For Dworkin, the commonwealth, that is our common life together as a political community, must be directed towards maintaining the ethical freedom of individuals. In this way, for the liberal tradition, personal autonomy acts as the fundamental principle that provides a normative justification for religious liberty. Jane Norton writes, "If we value personal autonomy, then we must value autonomy in relation to religious matters too." But we could equally say that religion as a term denotes the pursuit of moral autonomy, or a quest to cultivate our own sense of authenticity. In fact, if we take these claims back to a founding father of liberalism, John Locke, writing in the 17th century, Locke considered that God had granted individuals a property in his own person. This was a power to use one's own self, one's own body, one's actions, as one sees fit. Such a power emulated a voluntarist understanding of God, in which God's freedom was understood to reside in having a will independent of others. Society thus arose for Locke from these mutual bearers of property, or mutual bearers of freedom, each seeking mutual protection, or as he put it, the mutual preservation of their lives, liberties, and estates. He gave this the general name property. The task of civil authority then becomes regulating a society now understood to be formed by such natural rights bearers. Charles Taylor calls this the modern moral order. It is the predecessor of Dworkin's Commonwealth, a society directed towards maintaining ethical freedom. For Locke, the right to religious liberty is a central case of preserving one's property, or again, the power to use and develop one's own self as you see fit. In essence, he understood religion as the inward performance of faith, or knowledge directed towards one's aspiration for salvation. For Locke, such knowledge could not belong to any one person or be definitively identified. Indeed, he refers to the individual having absolute authority in such matters. This supported a new, emerging thought within radical Protestantism. The individual is bound to his own understanding of the Word of God, or the sincerity of his conscience claiming truth. Arguably, here we find the antecedent to our contemporary articulations of religion. To quote the Supreme Court of Canada, religion concerns one's self-definition. Of course, this precipitates ever-widening options, what the theologian Graham Ward critically calls the spiritualizing of subjectivity. There are then three conceptual takeaways from this discussion, shaping the liberal tradition's answer to what is religious liberty for. First, the liberal tradition proposes a distinct understanding of religion, one shaped by a particular history. Religion fundamentally concerns the individual's pursuit of personal autonomy or authenticity. On this account, as Ronald Dworkin has argued, a wide range of things may be religious, from the choice to be a Muslim or Christian through to living out one's choice or deep sense of sexuality. Second, This reflects, indeed arguably grounds, an understanding of freedom as liberty from restraint, or the freedom to pursue one's own vision of the good life. We are self-possessing, Locke argued. Third, such an understanding of liberty then leads to an account of political authority. Political authority exists to protect and maintain and manage diverse claims of liberty, the freedom of individuals as they come into contact with one another. But what is wrong with this way of thinking? This nexus between religion and liberty in the liberal tradition? I think there are a range of problems, including the impact it has on our understanding of society. But let me narrow this concern down to two problems for religious liberty. First, religion dissolves into a general category of liberty, which may then be subjected to a general law without difference. Second, religion as individual liberty means that religion must be balanced against other claims to liberty. And this impacts in particular on the formation of religious groups. Another way to put this, to pick up on our conference theme, the liberal tradition's understanding of religious liberty leads to potentially extensive limits on religious liberty. And that first, the religious group or practice must become subject to the general law. And second, the religious group's liberty must be or must potentially be balanced against other claims of liberty. Let me explain the first problem. Religion dissolves into a general category of liberty, which may then be subjected to a general law without difference. Theorists like Dworkin are clear. Because religious liberty protects authenticity or the person's capacity for moral autonomy, special protection afforded to some claims over others is arbitrary. For example, why should churches and organised religions be singled out for permissible discrimination in their employment practices? Other groups may equally wish to discriminate on different grounds. That's why we see the language of privilege applied to religious claims of exemption, or even something like charitable status. We may think of simply expanding protection, taking into account all different personal convictions, but that would make government regulation simply unworkable, a point Dworkin himself makes. Even if traditional religions are still singled out on this account, meaning we consider their liberty to engage in a practice against state law, what weight should that practice have? But is simply the personal autonomy of this particular group of individuals against the law's demand for what autonomy is stated, the collective judgment as to what autonomy demands, say, in anti-discrimination legislation, then why should the personal autonomy of, say, conservative Christians be able to compete with this? The end result of these reflections is potentially the imposition of a single universal law claimed to be neutral. All interests are treated the same regardless of content. All are simply instances of an abstract capacity for liberty. All should be subject to the same law. We face then the paradox of increasing heterogeneity. 1,000 autonomous flowers can apparently bloom as instances of ethical freedom, alongside increasing homogeneity. And now the second problem. Religion as individual liberty means that religion must be balanced against other claims to liberty, and this impacts in particular on the formation of religious groups. Consistent with his focus on the individual, Locke defined the church, or any religious group, as a voluntary society of men joining themselves together of their own accord. Many prominent theorists extend this line of thought today. They consider that the group is an aggregate of the individual interests that it serves. The church, for example, is a club or an association that coheres based on individual agreement and mutual interests. On this account, the collective right to exist or to pursue a common goal only arises through the cumulative interests of group members. The group, in other words, is a vehicle for individual autonomy. However, this logic establishes a possibility. The individual's claim to self-determination can defeat the group's claim to represent a distinct and liberty-constraining ethic. Of course, in many cases, the rest of the group will outweigh the individual. For example, courts and legislatures are likely to uphold the capacity of a church to dismiss a minister whose self-determination conflicts with the church, say by engaging in an extramarital affair. Simply put, the interests of other individuals in having a religious leader of their choice outweighs the minister's interest in developing this new life. But then consider how this dynamic can lead to curious outcomes. Here's what I consider to be a problematic case. Mr. Schuth was an organist and choir master for a Roman Catholic parish in Germany. He separated from his wife and began a new family. In the Church's eyes, this was bigamy. He was dismissed, and this dismissal was upheld by the German courts. Before the European Court of Human Rights, he then successfully argued that the national courts had failed to give proper weight to his right to privacy and family life. The court considered that the national authorities must balance what it called Mr. Schutz's right to personal development or self-determination and the Catholic Church's right to religious liberty. Mr. Schutz's dismissal, the court said, struck at the very heart of his right to self-determination. He was not continued in a position central to the Church's proclamatory mission. He was not a priest or the director of communications, for example. As a result, the Catholic diocese should have permitted him to remain in a position directing liturgical worship, while maintaining his contra-Catholic position on marriage. The correct balance, according to the court, effectively would have meant the Church facilitating Mr. Schutz's own conception of the Catholic faith, permitting his actions. He remains in the Church, but with his own distinctive. The Church becomes a vehicle for individual autonomy. What happens then is that we begin with an account of liberty, with each individual exercising the power to develop their own conception of the good or their own identity, for example. But this results in potential conflict, potential clashes of liberty. The general law is then seen as reconciling and reflecting the rights and interests of individuals. For example, do not discriminate. Religious groups who operate differently then face a twofold problem. Why should they be treated any differently? And must they in fact operate as vehicles for facilitating this liberty for individuals? The authority of groups and the differences they may reflect are thus flattened out. Any friction caused by a group's liberty-constraining ethic can be potentially resolved by subjecting all groups and individuals to the same uniform law. Now, locating the relationship between law and religion within a frame of personal autonomy is novel. Rather, the historical emphasis was on the relationship between groups and sites of authority, between the spiritual authority, the civic authority, and flowing from this a plurality of groups. Building on this, I think we can get a contrasting understanding of religious liberty. One, we may say, reflects what I'm going to call the Christian solidarity tradition. Here is my claim. Religious liberty can be understood as protecting principally two things. First, it protects against the coercion of faith and conscience, which I think should probably be understood as mediating a tradition. Second, and perhaps principally, religious liberty protects religion, understood as the free creation of communities of solidarity, fraternity, and charity, or what we might call right relationship, seeking the truth about God and instantiating this in manifold contexts. I suggest a claim like this with all its particularity is needed. A strong commitment to religious liberty requires understanding that religious groups exercise an authority that is both in distinction to government, but also coordinated or reconciled with it. Such groups must have independence. That is, they must not be entirely subject to or even delegates of the state. But at the same time, for this authority to be recognized, it must be grounded on a good goal, a purpose, or a good end that the state can be understood as serving. A religious group's authority cannot simply be constituted by the group's claim to liberty or freedom. Again, why this act of liberty, especially when balanced against any other? Rather, its authority must rest on the claim that there is indeed a higher good or a higher sociality that civil authority is responding to and even nurturing. A higher good that is appealed to and constituted in that religious body. A higher good, moreover, that is recognizable, attractive, capturing something of our deepest desires. I am attempting to capture this in my claim. Religious liberty serves a religious end, namely the free creation of communities of solidarity, fraternity, and charity, or what we might call right relationship. Now, what do I mean by this? We can examine this again through the same prism as the liberal tradition, how these terms relate to an understanding of religion, of freedom, and of the role of political authority. For St. Paul, pursuing God is manifested through the bestowal and use of a diversity of gifts. He writes of forming a body. Some are an eye, others are a hand. Each of these are parts that are integral to an organic whole. A person, on this account, is dignified not because he or she has the capacity for moral autonomy, but because a common orientation to God is realized in exercising roles and talents, and becoming a gift to others that then forms his body. St. Paul refers to this common orientation, our shared purpose, as the common good. This is an end or a purpose that transcends any one or many individuals, an end that we all share in and contribute to or strive towards. We must ask, what is the common end or shape of this community? This can be debated, can be provisionally understood, but in Christian thought, the end or shape of the community has often been understood as virtuous living. Let's think of this as solidarity, fraternity, charity. Solidarity and fraternity entail understanding our mutual dependence, our responsibility for each other, and recognizing what Pope Francis calls the charism of service that others provide. Our common task, Francis argues, is to form a community composed of brothers and sisters who accept and care for one another, recognizing each other's vocation, orientated towards this common task. Pope John Paul II considered that this entailed overcoming structures of sin, desires for profit, thirst for power, oppression of others to ensure security or economic gain. Forming such a body sustained and christened by charity, the love of God that must necessarily pour forth as the love of neighbour, God's beloved. In pursuing God, we are pursuing relationships of gratuitousness and mercy, in which we offer ourselves to one another as a gift to further bonds of love, in family, in work, in communities, and politics. Now here we have quite a different understanding of religion. Recall that for the liberal tradition, religion is the individual's pursuit of authenticity. But on this different view, what I'm calling a Christian solidarity tradition, religion means a distinct pursuit of particular practices. For Augustine, building on a more classical understanding, religion meant binding oneself to God. But this can't simply be an act of the individual, a personal pursuit. Augustine and the Christian tradition was not simply concerned with the vertical relationship between God and the person. Indeed, it can't be. If God is loved, and pursuing God, participating in God's life, necessarily calls us to deeper relationship with others. Thus, Augustine says that in seeking God, right flows from the source of rightness. As the use of flow here indicates, Augustine is arguing that if a community is oriented to God, then it will necessarily be forming right relationships within that community. True religion, he says, gives rise to a cooperative order in which all persons are given their appropriate positions. He called this the wholehearted and harmonious obedience of mutual affection. So, a different understanding of religion, forming communities of solidarity, fraternity, and charity, or what we might call right relationship. But this also reflects a different understanding of freedom. Recall again that for the liberal tradition, freedom principally means the absence of restraint, that the self-possessing individual's will is unhindered by others. We may pursue contracts, property acquisition, so forth, limited only by the freedom of others. However, for Augustine, in his wake, freedom is understood as pursuing what is truly human, truly good. God is ultimately free, not because he can do what he likes without hindrance, make the stars or don't make the stars, for example. Rather, God is free because his nature is unhindered by any corrupting force. He is the height of freedom because he is simply infinite goodness itself. On this understanding, a person cannot be free if he or she is pursuing the wrong end or they are suffering from debilitating passions and degrading choices. Rather, freedom means becoming what you are meant to be. And this means reflecting on what our nature, including our relationships with one another, require. We must aim on this account not for unhindered freedom, but the freedom of human flourishing. And so the purpose of religious liberty as a matter of freedom is then not simply moral autonomy, but rather the goal of right living, a right relationship with God and with each other. Finally, if we follow this tradition, we are presented with a different understanding of the role of political authority. Again, recall that for the liberal tradition, political authority exists to support and negotiate claims of individual right. But for this Christian solidarity tradition, political authority is tasked with recognizing and encouraging the formation of bodies, families, trade and charitable associations, civic groups, educational institutions, churches and analogous bodies that pursue love of God and of neighbour, as I have discussed. Importantly, this has also meant the plural exercise of authority. The church has authority to determine and debate its own doctrine and practice. The family has authority to build a community instilling virtue. The trade union or association has authority to pursue good ends, the dignity of workers. And political authority recognises this, encourages it, and if needs be, corrects it. As Rowan Williams writes, the political community should be supporting what is already supportive, nourishing what is already nourishing, in the primary communities that make up society. But this account also suggests limits to religious liberty claims, but not, I think, as expansive or problematic as those suggested by the liberal tradition. Two examples of the possible limits suggested by this alternative. First, a limit on who may claim to be religious. And second, a limit based on the dignity of the person. In 1976, the then still existing European Commission on Human Rights considered a claim from the Church of Scientology in Sweden. The group had been prevented from advertising its Hubbard electrometer, which the church claimed could measure a person's mental state. The Swedish court had considered that this was misleading advertising, and the group then claimed that that decision was contrary to religious liberty, as afforded in the convention. The commission disagreed. It concluded that the Church of Scientology's actions manifested, quote, a desire to market goods for profit, and so fell outside of the religious liberty protection. Now, there's a question of whether that remains good law. Nevertheless, it points, I think, to something of a correct suspicion. The religious act, to be religious, should be seeking something other than profit. I've discussed this something other as solidarity, fraternity, charity. This may matter to some legal cases. Anti-discrimination law typically provides exemptions for religious organisations or organisations with a religious ethos. For example, in Victoria, a body established for religious purposes is exempt from the duty not to discriminate on the grounds of sexual orientation. Now, this provision has been interpreted narrowly, with the court starkly contrasting a religious purpose and a commercial purpose, and that is problematic. Some groups may be engaging in commercial endeavours, but be entirely suffused in a religious aim. But perhaps it is right to require such an aim as fundamental and characteristic of the organisation. Profit-making with prayer time is not enough. It is the shadow, not the substance, of religion. I've also suggested that religion, on this view I'm developing, is intrinsically connected to forming bodies of people in which we experience the other person as a gift. This is fundamental to their dignity. They are an irreplaceable part in forming a whole, orientated towards our common end. What then if a religious group acts contrary to this goal, contrary to the dignity of the person, so understood? What if the group is not nourishing, as Rowan Williams put it? We immediately enter here contested waters. For example, if a Roman Catholic school denies employment to a teacher in a same-sex marriage, is this a denial of that person's charism of service, their dignity? I don't think so. I think if this conclusion were reached, we would be failing to take into account the claim of the community in question and the importance of its own authority. Let me explain my point in light of an ongoing debate. Recently, the Northern Territory government has proposed removing exceptions to the Anti-Discrimination Law for religious organisations. Instead, the religious organisation would have to apply to the Northern Territory Anti-Discrimination Commissioner and justify their behaviour. In practice, this would lead to questions like, does a maths teacher need to be Catholic or Anglican or Jewish, as the school so claims? More so, does a maths teacher need to adhere to a traditional sexual ethic? Same again for a parish music director and so on. Underlying these kinds of proposals, typically, is a liberal view that the group exists fundamentally to facilitate individual interests, the individual's deep identity or authenticity, which should then be irrelevant to certain supposedly functional tasks like teaching maths. The religious group on this view is limited by the claim of the individual. But the school in this scenario is concerned with cultivating an ethic of fidelity or right relationship within a traditional sexual morality. It may then want a maths teacher, all teachers, to be, for example, Christian of a traditionalist kind, because a teacher exercises authority by embodying character formation, but more generally because the school understands that its purpose means being a community that walks together a shared way of life. It has an ethos beyond facilitating individuals. I think that comprehending this, and not simply rejecting the school's claim as animus, requires accepting that our community has genuinely different views on matters of sexual morality and how this relates to building a just community. Such differences are not entirely a matter of clashing liberties, but rather may continue to manifest What I'm suggesting should be a shared commitment to solidarity, fraternity, and charity, or the dignity of the person. The school is claiming that virtues like fidelity, patience, chastity, charity are to be found in a traditional sexual morality. While there may be disagreement in the conclusion that the community reaches, we can nevertheless understand it is driven towards being a community pursuing human flourishing. That points to greater liberty for the association. However, there are undoubtedly instances where we must intervene, where the dignity of the person is diminished because the group is not pursuing human flourishing, because it is not pursuing the ends, the purposes of religion. True freedom demands as much. To conclude, I presented two responses to the question, what is religious liberty for? For the liberal tradition, religious liberty is understood as facilitating moral autonomy, in which religion entails individuals questing for authenticity or convictions that shape their lives. On this basis, why care about a particular religious tradition over any other instance of authenticity? How do we balance different claims, considering the religious group is now a vehicle for individual autonomy? Here we have a particular understanding of freedom as the power to dispose of oneself, limited only by others' equal and conflicting claims. Political community is understood as a site for regulating and negotiating such claims. In contrast, we can take a different tradition, a Christian solidarity tradition. Here, religion is understood as cultivating together a community of solidarity and fraternity, of love of God and neighbour. The religious group has its own authority, and the task of political authority is to facilitate this religious purpose. In doing so, political authority nurtures a community of communities in which there is difference but contribution to a common good. I suggested that this second tradition also raises questions of limits to religious liberty and in the legal sphere. But I think it also poses a challenging social, ecclesial, or theological question. I think we sometimes uncritically refer to freedom like a mantra. This was clear during the same-sex marriage debate, where religious groups were keen to state it's about freedom. And this appeared to be either an appeal to authority, like the International Covenant on Civil and Political Rights, or else it had the hallmarks of the liberal tradition, a claim of negative liberty, the right to non-interference, the liberty to pursue my own ends. However, freedom within the Christian tradition has typically not meant merely the absence of restraint. It could never simply be the capacity for our own moral autonomy. Rather, we are truly free to the extent we are pursuing good ends, which requires contemplating what it means to be persons or persons in relationship. Religious liberty is not therefore a matter of protecting a piece of territory or an inviolable space. It can never merely be a zone of autonomy, let alone a power set against another's freedom. Rather, religious liberty facilitates forming groups, relationships that pursue the love of God and of neighbour in light of God, groups that cultivate solidarity, fraternity, and charity. Groups, in other words, orientated towards the good. We need perhaps to re-understand liberty not in defensive terms, but as the positive freedom to create something good. This is what Christians have traditionally called upon secular authority to recognise and partner with. Indeed, it reflects the Christian project to build a just and good society. As I've argued, this does not mean that there needs to be complete agreement. Within our political community, many churches and religious groups disagree with the law on questions of sexual ethics, for example. But even here, it seems to me, a church is not simply asking for the liberty to be its authentic self. Rather, as I've said, it is building a community in which virtues like fidelity, patience, chastity, and charity are said to be found in a traditional sexual morality. There may be disagreement on the conclusion, but this is a good hint. A greater attention to the primacy of civil society would recognise this. But if our liberty is not orientated towards forming right relationship, not orientated towards the common good, then it would seem to be, in Christian terms, not freedom. So this may pose at the very least a social challenge sourced in a theological provocation. Namely, that we must narrate and demonstrate that obedience of mutual affection Augustine wrote of, the creative fraternity that honours each part. Or else, what could we mean in claiming the name of religion? Why else have liberty at all? Thank you.